Hi everyone, Carly back again. And today I wanted to do another video in our series that we're doing with the last Blue Law of England. Some of you may have seen our previous video. Hopefully you have. If not, go watch that and come back to this. And we're back to break it down like a renegade master. Sorry about that. Right, well, okay. What I want to do today is deep dive what we call a void order. And this is an ability to, well, clues in the title, to void orders coming from pseudo courts in effect. So if we kind of break down the language a little bit and we'll go from there, and bear with me because we're going to go into some deep detail the spell has prepared. Let's have a look. So when we're looking at these void orders, and we know that all administrative courts are, technically, don't like to say it, but I do, bullshit. And this is kind of what we've got to kind of move in our psyches, including myself. I think sometimes we can overcomplicate things, and we're going to try and bring it back to kiss, keeping it simple, stupid. And I include myself here because sometimes I can overcomplicate things. I can kind of know too much, and my cerebrum can most certainly run away with me. So when we're looking at things being ab initio or void, ab initio meaning from the beginning, to take it back to the beginning, calculated from first principles. And what we're saying by this is that these administrative courts, and all courts are administrative if there is no jury. They're all admin courts with no authority whatsoever. So anything coming from these pseudo courts is and can be void from the beginning, from the outset. So what we're looking at is null and void or nullification, and we're going to deep dive that a little bit more. Clues in the title, null and void. It's null and void. It is ab initio. We're going to look at the Fraud Act 2006, and as we know, fraud vitiates all. 1956, Lazarus Estates Limited v. Beasley, Lord Denning said, no court in this land will allow a person, corporation, to keep an advantage he has obtained by fraud. No judgment of a court order, no order of a minister can be allowed to stand if it has been obtained by fraud. Fraud unravels everything, as we know, and there is no time limit on fraud. We're going to look at theft of the intangible, which is our executive power of attorney as living men and women. This is, I'd like to say stolen from us, but in our ignorance, this is what we've given up. Hence the dumbing down of us, and why that is so important for those that have eyes to see. We just have to remember who we are and use the right words in the right order at the right time. Theft of the intangible. Then we've got connivance of court staff in fraud and deception. Ultimately, these are private-led prosecutions. As we know, the court is the paperwork, and this is the power of the void order. I've just sent one in myself, and I'll be giving you the results of that. And with the last Blue Law of England, we will be enforcing that in the court if needs be. But the void order does what it says on the tin. It voids it from the outset as soon as it's served, or should do. We've had some success in this, and that has been enforced in the court to make these judges abandon ship, shall we say, and we'll get into why. So this connivance of court staff in fraud and deception is clearly stated that Uniform Commercial Code 12103, where all parties must agree what law or state or nation the pseudo court conducts the jurisdiction in. Therefore, all parties agree a jurisdiction. The jurisdiction must be agreed, you must be told, is what that means, before it can progress. And this is clearly stated in the UCC, the Uniform Commercial Code 12103A, and also under Uniform Commercial Code 12103B. So what that means in simple terms is if they haven't informed you what jurisdiction that court is coming under, if they've not been transparent, because there's no transparency here, then it's void. We know the judges have no bonds. They are not on their oath. All they are stating is a corporate affirmation. Game over, 101 from the beginning. Ab initio, take it back. We know in the courts what they're doing is basically, fear and force. false evidence appearing real. It's fear that keeps the working man in line, as they say. And when we walk into the pseudo private places of business, the impression upon us is to lower our status and to make us feel lower, hence the pomp and the ceremony of it all. But ultimately, the guy in the big black robe has no more authority over you than a janitor at McDonald's. And that in these admin courts, they're just security guards. That is it. All administrative courts are and always were bullshit. And by this, we mean that they have no authority over living men and women, yeah. Only persons. And I think we're all kind of aware what a person is now. See person, see corporation. Court means dead, and ORATE means speak. And the dead can only speak to the dead. They can't speak to the living. If you go in there declaring yourself like a freeman of the land, they can't hear you. They can only communicate with the dead. But what we need to do is take back our power of attorney and our executive status as living men and women under the Constitution. Any court, as we've said, without a jury present is an administrative court. It is a place of business. Guilty, not guilty, comes from the Dutch gilder, to pay, right? And it's the trustee that has the fiduciary capacity to pay. And they are making us the trustee when we walk into those pseudo courts. All administrative courts are unlawful. Now, actions which overthrow and subvert the laws of the Constitution of the Kingdom and which would lead to the destruction of the Constitution are unlawful. This is law, not legal. Legal is only given the force of consent. It is a corporate policy. The case of R V Thistlewood, 1820, established that to destroy the Constitution of the country is an act of treason. Ministers acting in fraud, all acts and statutes are orders from ministers acting in fraud by claiming acts and statutes are law, when in fact these are nothing more than corporate policies for the private corporations. Lawful is very different from legal. The inhabitant is lawful under the Constitution, and the Bill of Rights legal is for the government employees only, and the Crown employees to obey acts and statutes. These are policies, not law, which is why they have to lower our status. Now remember, he who creates owns. We created government, not the other way around. They can't tell us what to do. We only delegated that power to them so they can conduct business of state on our behalf for the people, we the people, by the people, for our benefit as beneficiaries. And something's gone wrong along the way somewhere. I think we can all agree. So we now declare the void order as to the higher rights civil and criminal courts as declared in the void order in the case of Upjohn LG in Re Pritchard 1963. This void order was granted by fundamental defect in proceedings, as no notice of the proceedings was given, so that's a big deal, to the inhabitant. Remember, we are inhabitants of the realm, not citizens of the state. Citizen translating in the serpent tongue as municipal servant or employee, as we've stated. So no notice of the proceedings was given, strike one, to the inhabitant or disclosure thereof. This is a breach of due process of law and breaks due process and disclosure rules. They're not fucking telling us what they're doing, basically. That's what that means. And we aren't persons, we are inhabitants under the Constitution, and it is a subversion of our Constitution. We now submit further case evidence. Lord Denning, to your good selves. Furman v. Ellis, 1978. The court and the judiciary did not hold the jurisdiction as they are ultra vires. Ultra vires meaning outside of the power or authority. It's an ultra vires act of a public body or judicial officers under the colour of law. It isn't law, it is the colour of law. And colour in legalese, see Black's Law, means counterfeit. It's a twig. Committed the criminal act of theft under the Theft Act 1968, section 15, the untangible, our power of attorney, as to the case of Lord Denning in Perlman v. Governors of Harrow School 1978. Now, this is case law, and we've got to stay in lawful, not legal. Now, they are legal. They are public servants. They are there to serve us because we have a higher status than they do as living men and women. And it is the absolute hell-bent intent to lower our status to persons. So we have to follow policy, acts, statutes. I don't know if some of you have seen the de-establishment of the Christian church bill that they're trying to push through. Now that is one of the biggest subversions of our constitution that we can literally ever witness in modern times. They are treasonous in that essence, and we know that to be an inhabitant and a descendant of this land, Great Britain translating as people of the Great Covenant or people of the Covenant, people in power have to come from this land and have to have a descendancy from this land. I think you get where I'm going with this. Now, these magistrates' courts, Magi Strait, Magi Magician Strait, a long body of water, because we know it's all shipping terms in the shipping lanes. Ultimately, these are public servants who are now not acting in a public office under the Nolan principles, but are racketeering in private business through fear and force, as they always have done. Let's face facts, but let's not go there. So the magistrates' courts are in the criminal act of connivance, fraud, privateering, and allowing a foreign state court to act in the criminal behaviour of, see above, who are registered to the United States and running the court in secret from the inhabitants by conducting the court under UCC codes, Uniform Commercial Code. For this, by the so-called trust or associations incorporated, which is the organisation to carry on business for its own profit for that of its members, such as magistrates' courts and county courts. And these UCC codes, 1 to 3, that they're conducting these courts for themselves, not for the law and the realm of England. These are private places of business, and as the late great Baron taught me many years ago, makes the judge the janitor at McDonald's. And it is this fear and this railroading and this force that, you know, we don't really want to walk into some of their courts. The court is the paperwork, hence the void order and the power of the void order. But if we have to, then we must do. But we go in there by special appearance as the beneficiary under the Constitution, as an inhabitant of the realm, etc. and so on. No corporation can bring a man or a woman to court under the law of the realm of England. Let's just read that again. No corporation can bring a man or a woman to court under the law of the realm of England. This is a subversion of the Constitution. So these so-called authorities are, as we've said, acting outside of the given authority, and we gave them that authority in the first place. So only a living man or woman can bring a claim against a man or a woman, and that's lawful. So the next shitty trick is a jury trial. So there's a big difference between a jury trial and a trial by jury. A lawful court is a trial by jury by your peers. So a jury trial might look like a trial by jury, but it is not. It is a trial led and directed by the judge, who is not a judge because he's not on his oath or bond, just under an affirmation of a corporate policy. And again, has no more authority here without said bond or being on said oath than, I repeat, the janitor at McDonald's. Juries actually have the power to what we call, again, nullify. Annulment, it's called annulment by jury or jury nullification. Now, this is a powerful tool. Trial by jury is fundamentally a common law mechanism and is the primary feature of a democratic system of governance. Not voting in elections, as most believe. So if you haven't seen my video on the elections, go watch that. We don't vote. It's an opinion poll, and slaves give their opinions, and we are classed as debt slaves and slaves. Slaves, I did say. So trial by jury is not merely about judging on the guilt of the accused, important though that is. A jury also has the power to judge on the justice of the law. They can decide on the appropriateness of a piece of legislation. Now, that's a power that is reserved by the people, a jury of your peers. If they find it wanting, the jury doesn't have to say guilty or not guilty. It can nullify that piece of legislation. We are the power and true authority. And this is what we've got to start remembering. This is what we've got to get back to. We are being herded. Meh. You know, what is a you? You must, you owe, you. You is a docile female sheep. You is actually plural in our language, in our demotic cursive language. And we've forgotten that. And we are being herded into these administrative courts. And what is it about? It's about this. It's the gilder. Who's going to pay? Someone needs to pay. And we don't have the ability to pay, but that's another video. So this feature is a profound and important part of common law and, well, common law based constitution. Think about it, yeah? It places the people in authority over the legislature. Can I say that? Legislature? Legislature. I can't say that. So without this, let's have a think about it. So how can something be founded on nothing? The courts are a fiction in and of themselves. It is a foreign state renting a courtroom. This is the colour of law, not law, but the colour of law. It is a pseudo court, as we've said, in connivance with the states. So when we have a look at this, the defendant or appellant is entitled to expect the judge in a true trial by jury of your peers to conduct a thorough cross-examinations of the facts. Yeah. And where due process is willingly frustrated by the adjudicator, the judge, he's just there to steer the ship. Yeah. It's actually the clerk of the court that has the power, but that's another story. With independent witnesses, validating claims under oaths, which is how it should be done, with an accurate statement of truth and so on, then this bias of the judge or adjudicators is unlawful, and this gives a valid claim that the order is void. And hence administrative courts are just void in their very natures, as we can see. So what is a constitution primarily for? This is to guard against our own administrative government itself becoming criminal in nature. And I think we can all agree now that the government is criminal in nature. I mean, which psychopath do you want to vote for? The red one or the blue one? And we know where these people have come from. We know the lineages and lines of which these people are, etc. and so on. But again, that's another video. Let's stick to the facts. So we delegated our executive power. Delegated it. That's it. So that the business of state can be conducted in our name for the benefit of the people, not to be hijacked by corporate politicians and tyrannical corporate governments. The power was and always will be with us, the people. They have turned the tables around. You spin me right round, baby, right round, like a record baby, right round, right round. And we need to spin it back. It's not that we have to take the power back. We always had it. We have it. We just have to remember that we have it and enact that. Get it back. Square one. So they have turned it around upon us. They've deemed us as a fictitious state. And a state is a condition in a contract. This is contract and commerce, all registered to the United States, registered to the City of London under Dun & Bradstreet, all running from UCC, Uniform Commercial Codes. The Temple Bar, the Bar Mitzvah, the Temple Bar Mitzvah, the fake executor of your trust, our power of attorney handed over in our ignorance. We know when we hand our power of attorney over, we declare ourselves a lunatic and an imbecile before the court. Are we lunatics and imbeciles? I can't comment personally. I am a bit of a lunatic, but no, and I shouldn't say personally, but you kind of get where I'm going with this. Now, a person affected by both a void or voidable order has the right, ex debito justitia, to have the order set aside, which means that the court does not have discretion to refuse to set aside the order or to go into the merits of the case. That's Lord Green in Craig v. Canson, 1943. So we have the right to pursue and place in the void order, to void the order. So the conclusion on this case law that I've referred to above, the void order set aside can be made to the court which made the order, which is what I'm in the process of doing. One notice going to the Royal Courts of Justice, second notice going to the court, said court in question, and then we'll inform whom else we need to inform. But that case is going through currently, so I will keep you updated on that. The idea is through dark matters that we will be able to show people how to do this. The void order set aside can be made to the court, etc. Setting aside must be done under the court's inherent power, we use that term loosely, to set aside its own void order. And when we present them with these facts, and a fact is a fact and you can't argue a fact, then this is the power of it. And an appeal is not necessary as the order is already void. The court does not have discretion to refuse because the inhabitant affected by the void order has the right to have it set aside. So this is it. This is everything. Can you imagine all the stuff and all the crap that comes from administrative courts where they have no jurisdiction? Juris meaning lord, diction means words, law words. This is why a judge passes a sentence. He is sentencing you with law words. It's an illusion. All of it's an illusion in the minds of men. And with nullity and void orders, it's never too late because, as we've said, fraud vitiates all, and there's no time frame on this. Yeah. So you can go back, whatever that order was, or that, that the nonsense and the crap that you've been suffering and labouring under for however X amount of years. This is the power of the people. This is the power of the void order. This is the power of jury nullification. This is the power of a trial by jury. This is the power we have, the people, under the constitution of the realm. This voids the proceedings as if it was based on a void act. A void order does not have to be obeyed because it has no legal effect from the beginning. Yeah, powerful. The inhabitants can ignore the void order and rely on nullity as a defence when and where necessary. A void order is void in law, even if the nullity is unjust or injustice occurs to an innocent third party. Now, that's quite powerful as well. Now, remember, if there's harm, injury, or loss, then that's a common law, that's a crime, or it's a civil tort if it's a financial loss. But these administrative courts, it's all about generating revenue, always shipping terms to them. So no court, not even the Supreme Court, has jurisdiction to give effect to a void act, and the duty of the court is only to interpret and apply the law, not to reform or create it, as such powers rest only with the people. Let's read that again. The court only has the power to apply the law, not to reform or create it. As such powers rest only with the people. Yeah, and the inhabitants' parliament, the people's parliament. We are the parliament. Parley, to talk, mens, the mind. To talk to the mind. There is a lie in that, liar. And that we know that's what's happening. We know that's what's occurring. We know that we don't vote these fuckers in. So let's have a look at warrants. All unsigned warrants are illegal and cannot be enforced. E.g., take, for example, your car, yeah. It is the plates and the VIN number that is registered. The conveyance, I should say, is your private property. They can't take our private property. They can only take what is registered, which, again, is, say, the VIN number and the plates, just as an example. This is a private company trading as the police force, yeah. The police are an unincorporated corporation and therefore are an impersonation of a police constable, which is a criminal act and punishable with up to 14 years imprisonment. They have no letters of patronage or seal of authority of the people by the people, due to the Crown Agents Act being dissolved in 1995. Therefore, all Crown agents, police judges, Crown officers, etc., were all transferred to the Companies Act 1985. This again is subversion of the Constitution, which is a crime of treason of the nation. All public servants, civil servants, are now under an affirmation to a corporation. All public servants are not serving the public anymore. They have absolutely obliterated the Nolan principles and are working from a place of private office. We delegated our power, as we've said a couple of times through this video, but eat, sleep, repeat, to conduct business of the state for the betterment of the people. Legislation, acts and statutes are only for persons of the state or state citizens, not the citizens of the realm of England and Great Britain under the Constitution of Law or common law. We, the people, are the original power. It was only delegated to the trustees and reserved by the people. We reserved it. And we need to take it back because they are acting in criminality. And the original powers cannot be removed. Our original powers cannot be removed from us. Sexy stuff, right? Do you love a good handful of papers? Right. So know your true identification. You are the sovereign citizen. We are the sovereign citizens. From nature, the natural man or woman created in the image of God who stands under God's law and the constitution of law. You know, you are the executor, beneficiary, benefactor of the trust set AKV 1666. You are not corporate legal fiction straw man. Claim your authority back and your true natural standing. Standing. This is why we have soles of the feet. We are standing on the land, not floating. Well, like Jesus, we need to kind of float above the waters of maritime. We need to overturn the temples in our Father's temple and remove commerce from our minds. Be of the world, not in it. This is why we use scripture on legal documents. Sui juris, let's have a look at this, is a Latin phrase that literally means of one's own right, having the right and the capability to manage one's own affairs. And this is what we need to do. We need to take the power back. We need to be sui juris. We need to have standing on the land and remember who we all are. And I absolutely include myself with this. You know, every day is a school day for me and I'm learning. And the power that is held within this, that always was in our superior statutes, the Bill of Rights, etc., and so on, is a power to the people, reserved by the people. The system classes us as a ward, and this is why they call us serfs, pursers, and this is why they gave us out. This is why they give us awards. You know, you do something really cool, you little slave. Here's an award. Here's a certificate, a piece of paper instead of a brain. The straw man, the Wizard of Oz. And all we have to do is pull back the curtain and see who actually has the power. And it's us, not them. We need to be acting under our own authority. De facto v de jure. In jurisprudence, a de facto law, also known as a de facto regulation, is a law or regulation that is followed, but is not specifically enumerated by a law. Bullshit. By definition, de facto contrasts de jure, which means as defined by law, as a matter of law. And this is this huge difference that we have to really get into our noggins. Let's have a look at Penhallow v Doans, the Right Honourable Sir Jack Beatston, case law 1795. As we said in our previous video, the Sir Jack Beatston, via the London School of Economics, you know, we're not just making this shit up, the state is a company. They're in commercial business under the Uniform Commercial Code. Now, Jack Beeston, London School of Economics, what a state is and what a person is. Fictitious minds can't interact with the intangible, says he. This undermines everything now. That one line undermines everything that they are aiming to do to us. Can you imagine that everything that comes from these is void from the outset? We must claim our executor status, part from the straw man, and then become the executor and benefactor or beneficiary, and therefore appoint the judge as the trustee, as he wears the 3 crowns of corruption, the triple crown of Baal. 1, fake judge or landlord. We are the land that was stolen. This is why they decapitate us, capitus maximus, the capital letters, capitus. This is why we have our, you know, just our heads on passports, because they have removed the land. So first jurisdiction, judge is landlord over you. Second fake jurisdiction, judge is banker. Third jurisdiction, judge is priest. The triple crown of deception here, yeah? If you got this far, bear with me. Okay, so foreign state, 1 crown, Vatican crown, independent foreign city, priest, yeah? 2, foreign state, 1 crown, inner city of London, financier, banker. See judge, see banker, see postmaster. These are the postmasters of old, yeah? And that's why we utilise postal mechanics, the UPU. Foreign state, 1 crown, Washington, DC, representing the law, or the military arm, actually, as well. So ask yourself, has any foreign state have any jurisdiction over the natural man or citizen of the realm of England and Great Britain? The answer to this, no. I think I can pack up. But where's the fun in that? Okay. This would be a subversion of the constitution of law, which is treason against the nation. Therefore, all of the above are attempting in fraud and deception and fraud by omission in the court of in the act of dishonesty and entrapment forming two contracts. They are contracting the natural man into joinder with the straw man, giving the illusion that you are subordinate, subvertant to their authority as a commercial entity. Second contract is now between the joined man, straw man, and the corporation. They now steal your untangible, to access your trust fund. Trust fund? Trust funding fraud. Try saying that after a few words. Trust funding fraud. This is contrary to the 1968 Theft Act, Section 15, the untangible, They are stealing your executor status, your power of attorney. And this is turning us into these state citizens, A person, therefore, now directly under their control. Ladies and gentlemen, you are being scammed. And not only are they scamming you to this extent, this level of deception, then the cheeky bastards then fine you on top of that. So whatever sweat equity they then leave you with, you the man, woman, going working, you should be able to keep that. We know that there's no obligation to pay council tax. We know that there is no obligation because actually the liabilities of the inhabitants when governments incorporate under Section 79 of the Local Government Act, I think it's 1888, don't quote me, don't shoot me if I get that wrong, it becomes their liabilities. So not only do the king bastards do this, then they will come for everything else. This is a complete violation of Article 4 of the HRA, the Human Rights Act, and also the Modern Slavery Act 2015. Let that sink in. You are a slave, Neo. Slavery and servitude. A person commits an offence if a person holds a citizen man, woman in slavery and servitude under the circumstances are so that the person/state citizens, civil servants, public servants, ministers, judges, police know or ought to know that the citizen man, woman from nature is held in servitude by this system of modern day slavery. This compulsory labour for us to be taxed and taxed again. Again, the late great Baron said, and do read his affidavit, the tax man just loves tax. I think we were taxed to 85% of every pound. I think it's more than that now. Just let that sink in, as you would say. Let's have a look at the Terrorism Act 2000. And we can't be a part of terrorism. We can't fund terrorism as people. And that's exactly what we're doing with our taxes. And the Terrorism Act 2000 in the act of terrorism means the use of threat or action, and we are being terrorised as the people of the nation, where the use of threat is defined to influence government or to intimidate sovereign people. And I think that's exactly, we can all see that's exactly what they've been doing, and that's exactly what's been happening. Or a section of the people, because let's face it, you lovely people are here listening to me now, is made for the purpose of advancing a political, religious, or commercial ideology. And that's exactly what we've got. So I'm not afraid to say this is fraud, this is connivance, this is treason against the nation. And all of these actions fall within the subsections A, which involves serious violence against the citizen. And I think we can see that with the fake arrests, fake courts, fake fines, fake enforcement. No signature on a warrant. A warrant is therefore illegal, nullified, and void, and held in error. B, involves serious damage to property, i.e. removal of the citizen's man, woman from nature, from their dwelling. We have dwellings as inhabitants. We aren't residents. Resident means in legalese temporarily residing to do business. Well, we're not in business and we're not in commerce. C, endangers a man and woman's life by causing stress, alarm, and harassment. Tick. D, creates a serious risk to the health and safety of the man, woman, citizen. Tick. Designed seriously to interfere with the electronic systems to disrupt the information such as your data, and we know the importance of data. This is a data war. This is an information war, mark my words. Information will be the last commodity, data. And come and see what we're doing with the original Bitcoin and BSV with that. So Do I need to say any more? Let me have a bit of And I think what it is about stripping down the bullshit. There's so much information and misinformation out there, isn't there? You know, and it's trying to you know, claw that back and hopefully, you know, with the last blue bar of England, we're doing it. You know, we're not just gonna talk the talk rather. We're gonna walk the walk, and we're doing this, and that's what's important. It's not what we say, it's what we do. So let me just further qualify, if you would allow. Halsbury's Laws of England. Let's just have a quick look at that. Halsbury's Laws of England states that the oath does not authorise any judge or magistrate. Now remember, they're not on their oaths anymore. They're just on these affirmations, these corporate affirmations, in the common law jurisdiction of England and Wales to adjudicate any hearing in which the matter is to be decided in any other way than by trial by jury. That's in Halsbury's Laws of England. And if anybody wants these notes, feel free to email me if you'd like to kind of read them through whilst watching the video again, because this is what we've got to get into our cerebrums, you know. Furthermore, in the hearing in question held at the Magistrates County Court in Swindon, bullshit, on the date 3rd of July 2017, now this is important, where there is no injured party, corpus delicti, and no defendant, no clerk of the court, therefore the common law oath under which the judge magistrate should be under is unlawful and constitutes an offence contrary to Section 13 of the Statutory Declarations Act 1835. These aren't on oath, yeah? And it is my understanding, under Halsbury's Laws of England, that no magistrates or county court should exist. And when someone is summoned, it is an administrative meeting without any lawful existence. If this has transpired, it is a breach of the Fraud Act 2006. Boom. And the judge, magistrate, clerk, and prosecutor step outside of their lawful remit and become personally liable. And it is our ignorance, you know, and ignorance is no defence of the law, but it's in all of our ignorances and the brainwashing, the manipulation, and the rest of it. You know, we're not taught this, and purposely so. As the Pope famously said, you know, give me, or the Catholic Church in general, give me a child to the age of 7, and I will give you a minion. And this is this programming that we've got to deprogram. It is my understanding that demanding monies by false representation is in breach of the Fraud Act 2006, Section 2. It is my understanding that demanding monies without providing full disclosure is in breach of the Fraud Act 2006, Section 3. It is my understanding that demanding monies without providing evidence of authority or jurisdiction is in breach of the Fraud Act 2006, Section 4. Halsbury's on Administrative Law 2011. The law is absolutely clear on this subject. There is no authority for administrative courts in this country, and no act can be passed to legitimise them. Now, when we piece all this together, this is the power that we have, if we choose to exercise that power. These magistrates' courts, county courts, pseudo courts, we can give them 7 days to comply to the void orders, and so on. The constitutional rights of the people are secure. Yeah. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. Boom. You know, I'd just like to finish on a reiteration by Lord Denning, the Master of the Rolls, famously said the following: a void order is incurably void, and all proceedings based on the invalid claim or order are void also. Even a decision of the higher courts, will be void if the decision is founded on an invalid claim or void act, because something cannot be founded on no thing. Lord Denning in McAvoy v United Africa Co. Limited 1961. Over and out, my people. And just as a heads up again, Thank you for listening if you got this far. And we need to get this information out far and wide. We're going to make these documents and the ability to understand and act this freely available to people. This information needs to be out. This isn't something that we want to charge for, because what we're going to charge for, a charge is a commercial transaction. It's a charge on your energy. It's a charge on your time. We're just going to create another cabal, another form of people benefiting off the backs of slavery and others. And that's not how we roll. Obviously, we'll be discussing in more detail as these videos move on, where you can download these documents. We're probably going to set up some kind of drive, and then the link will go in the video so people can go and download them. But we'll talk about that a little bit more. If people can afford a donation for the work that we do, that's going to be brilliant. That just helps us just get this out. It's as simple as that. So much love to everybody. Keep on keeping on. As we say, you know, it's a commercial maxim using their own rules against them. And again, they have to follow their own rules. We don't, they do. Those rules exist for them, not for us as living men and women. But it is a commercial maxim. He who leaves the battlefield first loses by default. And the battle rages on, does it not? But remember, you know, be of the world, not in it. Get your popcorn, but be empowered in that. And we work together. God bless.